Officially welcome everyone to this gas and hydrogen seminar organized by the research group of Natural Resources and Environmental and Climate and Energy Law of the University of Bergen. Very long name. Great to see so many familiar faces and people around here to discuss very important topics connected to hydrogen and gas. As we know, we live on unfortunate moments. There's currently a war right at our borders here in Europe, and this is creating a lot of impact already in a market that was under a lot of scrutiny and discussion some weeks ago and some months ago, even before it started, and that is the market for gas. At the same time, we see that the technological development is also pushing and creating opportunities to fight climate change, but also to modify the way that we do and deal with energy. And because of that, we have today the great opportunity to have among us three really wonderful speakers to talk about the gas package, the hydrogen package, and the implications that this will have for Norway, and importantly, for also the maritime sector in a way. This seminar is accompanied also by a video that is available on the website where the seminar has been suggested, which I'm going to link right now in the chat. And here you will be able to listen to Professor Gunnar Eskeland from the School of Economics in the Norwegian School of Economics, where he speaks about the importance of including the carbon and hydrogen package within the understanding also of the maritime transport sector, which is an area that for a country like Norway, it's so vital. So I would recommend you, if you have a little bit of time, you can look at this at any other point. And somewhat not necessarily connected with this, I would like to share and take the opportunity of having so many people here today and to give some good news that are come to the University of Bergen. And they are connected to something that we got a good news on Friday. Friday afternoon, it was decided by the Norwegian government and the Norwegian Research Council that the University of Bergen, Norse, University of Stavanger, the Western Norway University of Applied Sciences, the Norwegian Business School of Economics, Tøy and Fridtjof Nansen Institute, we're going to be hosting a center of renewable energy linked to hydrogen. And the Faculty of Law of the University of Bergen will be playing a role in this new center that is named High Value. And the idea with the center is to try to create new knowledge connected to the field of hydrogen regulation through the whole value chain. And here law has a role to play. And here what we will try to do is we try to discuss in which way we can integrate hydrogen in different aspects with a maritime flavor. So this was completely not expected. It was a great news for all of us. I didn't even know what time they were going to decide whether we were going to get a center or not. But luckily, we received funding for this to work in the next 8 years. And in a way, this connects very well to the presentation and the talks we're going to have today. With that being said, I'll stop sharing my screen. And then I would like to give the word or the floor to our first speaker, which is Professor Leigh Hancher. Leigh, like all the speakers today, needs no introduction. I will keep it very brief. She is one of the most brilliant persons in the field of energy and state aid. She has a trajectory that is only to be admired and envied by a lot of people, including me. I would like to have 10% of the knowledge that she has. Leigh combines not only her academic expertise with also private practice. She is a partner, she's a counsel in Baker Botts, where Matthew Levitt is also working. So she has this combination of academic life, but also private side, which is something also that both Matthew and Henrik share with her. So Leigh, you have the floor completely yours for you. You have 23 minutes until 13:30, if I'm not mistaken. You have a little bit less time or more time, depending on the flexibility, but now the screen is all yours. So
thank you. And you will load my slides.
Yes, I will upload your slides. And give me a second so I can look for them.
Because with your kind remarks, you forgot to include that I'm totally technically incompetent. So
that is not true, Leigh. You're very competent, also technically speaking, but I have here your slides, so that is not going to be any problem. So you just let me know. Next slide, please. Next slide, please.
Thank you very much.
Yeah, just 1 second. I need to find my Zoom meeting here. Can you see the slides of Leigh in your screen? Excellent. Leigh, the floor is yours.
Thank you very much. So good afternoon, everyone, and thanks again for the invitation, and thanks to Ignacio for all the organization in Bergen. The idea for me is to give really a snapshot. I only have 20 minutes. It's a complex package, so I want to just go through some of the highlights and maybe also some of the controversies. Of course, this package was conceived and adopted at Commission level before the terrible events in Ukraine. So there's going to be quite a bit of discussion as to whether we're looking more at a gas market that needs to guarantee security of supply. And that is currently rather underdeveloped in the package. We have the new toolbox that was announced last week, and we will have more measures being announced at the end of April that will deal with security of supply, and maybe that will be worthy of a separate discussion. So what I'll be talking about, and if I could have the next slide, please, is the proposal that came out on the 15th of December that is linked to the earlier proposal, the so-called Fit for 55 package, where the Commission proposed various measures to encourage the production and the use of renewable energy, whereas the second part of this package, the so-called fourth gas package, is really then focused on moving hydrogen and low carbon gas or renewable gas into the market. There are two other measures that were launched at the same time on a new methane strategy, as well as a revised directive on the performance in buildings. But I won't be talking about those today. My focus is only then on the so-called fourth gas package. So next slide, please. It's quite important then just to remember there is supposed to be a close relationship between the first part of the package, the Fit for 55 package, as well as this later package. So as I mentioned, the first part of the package is all about production and promoting demand and use of new forms of renewable gas, whereas the December package is about creating a market to decarbonize gas consumption, and is really meant to put forward measures then to support the creation of a new and dedicated infrastructure, as well as to ensure efficient markets. Together then the idea is to remove barriers to decarbonization in different ways, and maybe then to allow the market to make the choice, the crucial and much debated choice, with whether or not we use more electrons and less molecules. Do we then try to electrify as much as we can, and we keep gas to the hard to abate sectors? This is a big question. Now, one of the key criticisms one could have of the new proposal is that it effectively does not address that crucial question, because we still have, separate packages, one for gas, one for electricity, and they don't together deal with what's really key, which is how to promote sector coupling or power to gas. So I think that will be something, a criticism that will come back again. Next slide, please. So the Commission's proposals and for the package, just as with the third gas package, we have a regulation and a directive known in the jargon as a recast regulation and a recast directive. So that means that the Commission has kept as much of the old measures, but then amended them and supplemented them. And these old measures then, of course, will no longer have legal value. But that process is called recasting. And as I've mentioned, the idea is then to establish an EU-wide market for hydrogen. What's really novel perhaps in the package are the rules for hydrogen, because if we look at the rules for what is now referred to as gas, and that is a concept that includes both renewable and low carbon gas, as well as low carbon hydrogen. These rules are essentially carried over from the third package. Now, for the new market rules, so the rules for hydrogen, the idea is to move forward in two phases. So we will have a sort of before and after 2030 approach. And before 2030, the new rules that will be introduced will be sort of suspended, and member states through their regulatory authorities can grant regulatory holidays for hydrogen investment, at least up to 2030. And those regulatory holidays will extend to the basic rules that we are familiar with for gas from the third package, so unbundling, regulated access for third parties, and tariff control. Now, the proposal is to set up a new governance structure for hydrogen and to create this new network of network operators for hydrogen, and to then promote a dedicated hydrogen infrastructure and cross-border coordination, and also to perform the same function as we see ENTSO-E for gas and ENTSO-E for electricity and ENTSO-G for gas performing today, which is to elaborate on the very highly technical rules that are transformed into network codes and even more detailed terms, conditions, and methodologies. Now, the fact that there is a separate network for hydrogen operators being proposed is already indicative of the fact that maybe we're not thinking in terms of sector coupling clearly. And for a simple question to the Commission, like, can an electricity TSO or a gas TSO also be a member of this new NO? There is no clear answer yet. So this is all work in progress. The next slide, please. So as I've mentioned, the idea is to increase the use of renewable and low carbon gases, and that they should then access the existing natural gas grid. There are blending obligations, for example. There are proposals to remove tariffs at cross-border interconnection points, IPs, and to lower tariffs for these gases at injection points. Importantly, there will be a new certification system to establish that indeed these molecules are green, and they will be accompanied then by these certificates on their journey from their point of injection to their point of use. And so the idea then is to make sure that we have a level playing field, so that consumers also can assess the full greenhouse gas emission footprint of what they are consuming, and this will allow member states also to include them in their energy mix. Now, controversially, the proposal as of December requires that long-term contracts for unabated fossil fuel gas, and that means then without, I think, carbon capture facilities, should not be extended beyond 2049. Now, we'll have to see how that, if that proposal now will be carried forward, given the concerns to security of supply. The fourth gas package will essentially mirror what we see in the fourth electricity package when it comes to consumer empowerment and protection. So the idea is then to promote more active consumers, to switch suppliers, and to be able to have access to better price comparison tools, get better billing information, etc. Again, there's a criticism here that these provisions tend to focus actually on conventional gas and not really fully on renewable and low carbon gas, especially when it comes to energy communities. There seems to be not sufficient attention being given there to these renewable gases. However, the key intention or objective is that consumers should be able to choose between renewable and low carbon gases over fossil fuels. So moving to the next slide. Hydrogen then, as I mentioned then, this is the main innovation. We get a whole new section of rules to promote them, the rollout of a fit for purpose hydrogen infrastructure with better cross-border coordination. And also to enable then repurposing of existing gas networks to transport hydrogen so that we don't get involved in all the costs of building a completely new infrastructure. Now here then, as I mentioned, this is where the regulatory holidays come in. The Commission recognises that given that hydrogen production is still in its sort of early phases, and it's also rather localised, then it might be the case that we should regulate with care, but at the same time, you don't want to create natural monopolies with all the problems of access and trying to make sure that everyone can use these facilities. So the separate chapter then in the directive, and there are separate rules also in the regulation, contains then quite detailed rules on the operation and financing of these new networks, as well as on all the transparency of gas quality parameters and hydrogen blends that should be applied in that sort of repurposing of existing networks process. What's also very interesting, and indeed Ignacio has written about this too, is that when it comes to unbundling, the Commission is proposing a stricter approach than we see for natural gas. So for hydrogen transport, we will only have two models, the ownership unbundling or the ISO model. So that means we will not have what we call the ITO model, the independent transmission operator model, which allows a vertically integrated firm to continue to own transmission assets, but to keep them in a separate entity subject to these so-called ITO rules. Now, the Commission thinks this will not be necessary because this is not new. Because it is new and we don't have existing networks in the hydrogen field that need special treatment. So this stricter unbundling would only be introduced along with the regulatory third-party access and tariff methodology control in the second phase. And now moving on to the tariffs. This is again, thank you, this one. Yeah, this is again a very controversial element in the new proposal. And it's quite funny because the impact statement that accompanies the new measures, in fact, indicate that there wasn't actually much support to do this, but the Commission has nevertheless gone ahead and proposed to abolish interconnection tariffs on hydrogen networks and also to introduce tariff discounts for renewable and low carbon gases. And these tariff discounts are quite large, 75% at production points and storage points, and 100% for IPs and for LNG terminals. Now that means then that the countries most impacted, where the gas is coming in, will be the ones that will lose revenue. And there is then provision for a so-called ITC mechanism. So this is a sort of compensation mechanism between the TSOs. So the one TSO that is earning more revenue will compensate those who are losing revenue from this mechanism. The idea is that the NRAs, the regulators, should provide them a long-term assessment of how tariffs should develop after 2030 and up to 2050. Now, interestingly, the regulators and through ACER and the European informal body of regulators, the CER, have all voiced their objections to this provision. This so-called ITC mechanism, so the inter-TSO compensation mechanism, is sort of borrowed from electricity. And anyone familiar then with that system knows that it took about 20 years to work out some kind of ITC mechanism. So some kind of mechanism to compensate between the TSOs, and perhaps the regulators don't want that headache all over again. So this is controversial, and we have to see whether that set of provisions will survive to the final version of this regulation. Moving on quickly. Now, as I mentioned at the very beginning, security of supply was not on everyone's mind back last year, and now it, of course, is one of the major issues. Now, the draft does include what are called solidarity obligations, and it builds on an earlier regulation from 2017, which is called the Security of Supply Regulation. And that's perhaps a misleading label, because that regulation doesn't cover the commodity gas. It's all about using infrastructure. And actually, it contains not a single word about commodities. And if you try and do a Google search of the regulation or any other kind of search of the regulation based on the term storage, you'll not find it. So even in December last year, before the current war, there was already a bit of head scratching going on. And the provision here is that these solidarity obligations, which are just sort of bilateral arrangements, informal arrangements, should be encouraged, and they should extend to renewable and low carbon gases. Maybe also just to mention here, of course, a lot of low carbon gas, renewable gas will also be imported because the EU does not have enough resources of its own. So we're also looking then at major security issues going forward. So the most that we had on the table in December is an annex with a sort of mandatory template on which this solidarity measure should be based. So it was rather, you could say, just a little stone flung in the pond at the time. Moving on now to the next and last sets of slides. There's quite a complicated provision or set of provisions on governance, which really will align the new package with what we already have in the clean energy package for electricity. So lots of plans that the TSOs are supposed to come up with. And these plans should be better aligned for both gas and electricity and hydrogen. I won't go into that in much detail. If I can move on to the next slide, please, Ignacio. There are a lot of open questions. I've put on this slide just a few of them. Maybe the most perplexing of all is that we actually don't have any hard definitions of what's renewable and what is low carbon. And the Commission sort of intends to kick those issues down the road because these are controversial, and put them in a delegated act. And this will then be introduced in 2024. And one of the problems is, well, if you don't know what's renewable, how can you then certify it and issue guarantees of origin until that date? Now, some people argue we can look at what's the types of systems and standards that are being devised under the Renewable Directive, the so-called Delegated Act on Additionality. might provide some guidance, but this is not complete. So this is one of the really complicated and perplexing issues. When it gets to the tariff discounts, there was already a big discussion last year about, how do we treat storage? Storage already did enjoy a special rule. And the idea then is, well, should storage get an even higher discount? Because gas tariffs are based on exit and entry, and storage, if you put it into a storage facility, it pays on entry, but if it's coming out the next day, it was exempted from exit, as it were. But the new toolbox that was published last week actually now to encourage storage will in fact introduce a lot more flexibility on storage tariffs. So that discussion might be already resolved through the policies adopted under the new March toolbox to deal with the current crisis. Now, one of the other big legal issues here is how we deal with cross-subsidization. And there's a lot of discussion as to how much cross-subsidization between, let's say, the natural gas network that we already have and the costs of repurposing it for hydrogen or building a new hydrogen network should be permitted. Because after all, the consumers linked to these networks will not necessarily be the same set of consumers. And so especially from large natural gas consumers, there's a lot of concern that they will have to contribute to the financing of a hydrogen network that they won't use. So that is also a big issue. There's lots of issues around determining how to deal with blended gas. So there's an obligation to blend at least 5% of natural gas with new renewable gases, but that of course has an impact down the line on how pipelines then are actually operated. And of course the appliances that are eventually connected to distribution grids and whether or not they are safe. Okay, moving on. And I think I have to wrap up, but you'll see that I think that one can safely say that this package is attracting criticism from all sides. Moving then to the final slides, I've just listed some of the criticisms that we're seeing. The absence of the definitions I've already highlighted. Not knowing what renewable or low carbon is rather complicated if you're trying to run a business where you're supposed to be moving towards producing those very things. The gas industry would have liked to have seen targets, just as we have for renewable electricity, but there are no targets. So no targets, say, for producing so much renewable or low carbon gas by 2030. That would, I think, have helped them to get more subsidies to do so. There's a lot of criticism on the unbundling rule change. Why do we have to abandon the ITO model, which worked quite well? Moving on, there's criticism from the regulators. They don't like, as I mentioned, the tariff exemptions. They're not very keen on cross-subsidization either, because they don't think that it's a good idea to allow cross-subsidization between energy carriers. They would like to see clearer rules on what they call horizontal unbundling. So they want to make sure that if you have a gas network operator, it should be clearly separated from a hydrogen network operator, but in a horizontal construction. So there should be some approval by NRAs and mandatory, separate accounts. That word dropped off. And finally, the last set of criticisms that is worth looking at are those from NGOs, from climate activists, who are very, of course, vocal in the field, who are not convinced that this package is enough to get rid of fossil fuel, and doesn't really, but by allowing so-called low carbon gases, it will actually just prolong the use of fossil fuel. It doesn't put clear a clear prioritization further forward for really renewable hydrogen. It does not avoid the risk of oversizing future hydrogen grids. So there are many criticisms here that in fact it's a weak proposal and it will just allow the continued use of fossil fuel that the Commission has, if you like, sold its soul to the devil, and will allow the continued use of fossil fuel as a default after 2050. So I think I've used my time, Ignacio, so I'll end here. I hope I've given you then an idea of what's in the package, and happy to take questions when we're ready. Thank you.
Yes, I thank you so much, Leigh, for this very thorough presentation and kickstart. We will take the questions at the end so that we have enough time for all the speakers and hopefully also for discussions. We're going to move on now to another very interesting and very relevant topic. We are discussing how we're organizing markets of gas, but at the same time, we are creating markets that are going to be competitive. In the same time, we are realizing that these markets are also involved in an issue of how are we going to do an energy transition when the costs are so enormous. And in connection to this, we see that we're trying to create tools that are going to push for sustainability. But we have rules that are prohibiting at some point collaboration between firms. And that's where Matthew Levitt, that is a partner in Baker Botts, is going to come in and tell us very interesting ideas about what's going on in the world of competition law and sustainability. And I think this is a key aspect that is going to be connected to all the hydrogen networks that will be constructed in the future, but also other relevant energy projects that we're seeing. And then what is the role of sustainability and climate change that has to play in revisiting perhaps the prohibitions that we have when it comes to competition between different actors in the market. Matthew, looking forward to hearing what you have to say. You have about 20 minutes.
Yeah,
so
sure.
starting from now.
Okay.
You have your own slides?
I'll try, yeah.
If not, I have yours as well.
All right, I'll give it a go. Okay.
There we go.
Yeah, there we go.
It's all yours,
okay.
Matthew. You have 20 minutes.
All right, thank you. Okay, hi everybody. Nice to be speaking to you all. So, there we go. Yeah, so I am going to talk about the relationship, sometimes difficult, sometimes, well, mutually supporting, between the various sustainability goals and the European legislation that's meant to be underpinning them on the one hand, and the competition law rules on the other. And it's a tension that comes up recurrently. I mean, almost, well, maybe a slight overstatement, but pretty much whenever there is some form of regulation, particularly regulation that requires or encourages cooperation between actors in the same market, competitors in particular, the question does invariably arise, well, does that immunize that cooperation from the application of the competition rules? And to what extent? And the answer is frequently, no, it doesn't at all. It's possibly even a minefield because it's encouraging cooperation on the one hand between competitors without actually providing any, you know, formal, direct, enforceable immunization from the application of the competition rules that a competition authority like DG Comp, with all of its, you know, aggression and self-confidence, would respect. And that's been a, you know, prevailing issue down the years, and it is no less present in relation to sustainability. So if we just think about the sort of cooperation that might be involved in attempting to achieve any sustainability goals, I've just listed a few here, and they very much pick up on some of the things that Leigh Hancher was just talking about. So standardization, labeling, definitions, certification, the sharing of data, monitoring of compliance, boycotting, you know, or joint investment, and then issues around recycling. And in fact, the European Commission and the UK Competition Authority actually launched dawn raids just 2 days ago on, I don't know exactly, but probably all of the large global car and van manufacturers and their associations in relation to an alleged cartel involving the recycling of end-of-use vehicles and vans. I don't know too much about the investigation, but that sounds a bit like it was something that, in the minds of the manufacturers was a good thing that they were trying to do, but clearly has at least raised the suspicions of the competition authorities. So where is the line to be drawn between these laudable ambitions and competition law compliance? Because you're in Bergen, and I'm talking to the University of Bergen, I thought it was right to say something about shipping. So just one slide here, and I'll say a little bit more on the next slide about how shipping is relevant to this whole set of issues. So Fit for 55 has a whole policy stream in relation to the shipping industry and attempts to promote the use of renewable and low carbon fuels in the maritime transport industry, with some quite ambitious targets, reducing the use of onboard greenhouse gases by 75% by 2050. And then there's a whole list of proposals, including setting reduction targets, requirements for the use of onshore power supply, principles in relation to the counting of biofuels, biogas, renewable fuels, establishing a certification system, and then a whole system of monitoring, reporting, verification, inspection, and enforcement procedures, including penalties. And to the extent that any of those things are left to private actors to sort out, and I wouldn't be at all surprised if the final two points there do involve some sort of privatization of the implementation and enforcement, certification, monitoring, etc., which is very much present in the maritime industry. To the extent that any of those things are left to private actors collectively to implement and enforce, then competition law immediately comes into play, notwithstanding the fact that they might, those goals might stem from EU legislation. And this is obviously a very hot topic of conversation in the maritime industry. I've just put up here two headlines from Lloyd's List from this week. So first, MOL, which is often described as the biggest shipping company in the world, the Japanese company Mitsui, has formed an alliance to develop methanol-fueled tankers. So it's an alliance of 6 companies. And I know there are loads of other alliances between shipping companies and energy firms. I think DFDS and Maersk and Ørsted have some form of alliance similar to this, or joint venture. And then the second headline I've just added here is Maersk, Danish company, joining calls on the IMO, the maritime arm of the United Nations, to enshrine life cycle emission rules. To develop guidelines and not leave loopholes in deciding what is truly green. So, an attempt to sort of place some sort of legislative framework around some of these targets, which is obviously good in itself, but also helpful insofar as it takes the burden off private actors to set those sort of targets because of the competition risks that might follow from that. But again, one has the question, even if the IMO, UN body, was to publish emissions rules, would they be directly binding on private actors? So would they provide all of the protection that competitors might need? That's really by way of background. And actually, just before I move on, 2 other points that I'd make in relation to the maritime sector. In liner shipping, so containerized scheduled shipping, alliances, space sharing arrangements, consortia are extremely common. And one of the justifications for those, or one of the benefits that those forms of space sharing arrangements typically achieve is reducing unit costs, producing economies of scale, improving frequency, by doing all of those good things, reducing emissions and the need for fuel, consumption of fuel. The other very common form of cooperation outside of the liner shipping sector is pooling arrangements, which are very common in relation to tanker, liquid bulk, other forms of bulk shipping, which also achieve various sort of economies of scale, which might also help to advance some of these sustainability goals. So just going quickly on, the Commission, headed by Margaret Vestager, has been very open, very determined to demonstrate their enthusiasm for the sustainability goals, the Green Deal, through competition law, recognizing the need for them to provide guidance in support of Europe's green ambitions. So they have now quite recently published some draft guidance. A number of other national competition authorities have been ahead of the Commission and also produced guidance. The Dutch Competition Authority was the first. So I say the Commission recently produced draft guidance. UK Competition Authority produced guidance just earlier this week, I think. So it's a very hot topic of conversation in the competition law community. But just before I go in and talk about what the Commission is saying, I just wanted to mention, again, by way of scene setting, some comments from a General Court judge, an Irish judge at the European Court, Suzanne Kingston, who was recently talking about the draft Corporate Sustainability Reporting Directive, which has some rather sort of loose wording about, on the one hand, the potential for horizontal cooperation between companies to prevent or mitigate environmental impacts, and then with some rather sort of loose wording, provided it's compliant with competition law. And I mean, unsurprisingly, the directive doesn't say when or how any of that sort of cooperation might or might not be compliant with competition law, but it does put a rather big elephant into the room. And so I've just quoted two comments from the judge, which I think are quite pertinent. First, difficulties certainly remain in working out the interface between the new generation of legislative initiatives on sustainable corporate governance and competition law. That is especially so, she comments, where the legislative framework doesn't actually mandate a precise activity, but some latitude is left to the company. And that is really, it's in that space, that gap, that the risk can arise. So on to the European Commission's guidance. It's been published by way of a new chapter to the Commission's draft guidelines on horizontal cooperation. This is the, that's where you could find it. It, broadly speaking, talks about three categories of sustainability agreements: those that don't give rise to competition concerns at all, those covered by the basic prohibition in the treaty, and those that satisfy the exemption criteria. And then there's some guidance on how those exemption criteria might be satisfied. And just one word before I go on, it is worth bearing in mind in relation to the sort of hierarchy of norms point, that the competition law rules stem from the treaty itself. So they're primary law, than which there is nothing of any higher status in the European architecture. And so that means that, and this is what empowers DG Comp, it means that the competition rules do trump any secondary legislation, which is essentially subject to the application of the competition rules. So first, sustainability agreements that don't give rise to any competition concerns at all. So the Commission provides a number of quite helpful examples, I think, which are intended to identify types of agreement that don't affect any parameters of competition, such as price, quantity, quality, choice, or innovation. So agreements on measures to eliminate single-use plastics, or on the creation of a database containing information about suppliers that have sustainable value chains, or sustainable production processes, sustainable inputs, or agreements between competitors relating to the organization of industry-wide awareness campaigns, provided that those campaigns don't actually amount to joint advertising of particular products. So all of those good things, which are, I think we're very aware of, which are pretty common, the Commission is clearly keen to encourage. So that's sort of the easy part. And then they talk about and provide guidance on the kind of sustainability agreements that might fall foul of the basic prohibition, with particular reference to sustainability standardization agreements. So what do they mean by that? So, for example, agreements to phase out, withdraw, or replace non-sustainable products, such as fossil fuels, and processes with more sustainable ones. Or agreements on purchasing production inputs only if the purchased products are manufactured in a sustainable way. And the Commission recognises that these may increase production or distribution costs and therefore prices downstream. If that is the case, then we could be in a situation where we have competitors agreeing to do something which results in increased common costs and increased sales prices downstream. And similarly, I used the term at the beginning about boycotts, and so that could be involved. It's another way of describing some of what's going on here. So it could fall foul of the basic prohibition, but it's not necessarily ultimately unlawful. So then the Commission gives some more guidance on the kind of sustainability standardization agreements that should be acceptable and compliant. And these are some basic principles which have evolved in relation to standardization agreements, broadly speaking, in any area, with a few quite interesting tweaks. The basic principles are all about transparency. Anybody should be, at least any interested actor should be able to participate. It shouldn't be mandatory to participate. It shouldn't prevent the adoption of higher standards. It shouldn't involve the exchange of commercially sensitive information in the development or adoption of the standard. There should be effective non-discriminatory access to the standard. And then this next point is a sort of interesting tweak on the usual principles. Shouldn't lead to a significant increase in price or a significant reduction in choice of products available on the market. And obviously the Commission recognises that both of those consequences might result, and so they have emphasised, this term significant. And if that does, if that effect does result, then there will need to be a deeper assessment. But they're obviously not ruling out the possibility that prices might result or choice might reduce as a result of such an agreement. And then finally as well, mechanisms for monitoring and enforcement to ensure compliance with the standard, which is obviously a necessary component, but clearly itself, it implies some sort of gatekeeping function. So then just going on, assuming that there is a significant increase in prices or reduction of choice, then then what? Is it still possible to satisfy the exemption criteria? Of which there are 4. So I'll quickly go through what the Commission says about these. First, efficiencies and benefits. That should generally be pretty easy to demonstrate. If this is some sort of genuinely legitimate sustainability initiative, then the efficiencies ought to be relatively easy to demonstrate. Cleaner production, etc., less pollution. Next question then is the cooperation indispensable, necessary in order to achieve those benefits? It may be the case that there is already, or there will be, law that requires undertakings to achieve those very same benefits. If so, is it really necessary for competitors to come together in order to do the same thing? Quite possibly not. So the regulatory legislative setting would be very important to the assessment of that criterion. And then also, is it necessary to avoid free riding on the investments required to promote a sustainable product? And are there any other economies of scale, for example, in relation to the establishment and monitoring of the standard? it may well be necessary to cooperate in order to do that, to get sufficient scale and acceptance. Third criterion is pass on to consumers. And this, in many ways, is the most difficult one. And the Commission approaches this in various different ways, considering the various different levels at which benefits might be shared with consumers. So there might be individual use value benefits. So if consumers directly benefit in terms of the improved product, and they also may be positive externalities and non-use benefits, such as reduced pollution. And there could be collective benefits, which flow to the users, but also to society more generally. And then there are difficult sort of trade-offs as well, because there may well be environmental benefits to the producers of a particular product who are far removed geographically from the users of that particular product. If you think about cotton production, for example, or working conditions, in Bangladesh in relation to clothes consumed in Europe, the benefits, there may be benefits in relation to both groups of producers and consumers, but very different. And how do you actually evaluate those? How do you quantify them as well? And as the Commission recognises, current experience with measuring and quantifying collective benefits remains scarce. And then finally, the fourth criterion is no elimination of effective competition, which means that competition should remain, notwithstanding the cooperation involved in the creation of this sustainability agreement, in relation to at least one other important parameter of competition, such as price. And there are also some quite interesting comments about timing, trade-offs between a limited period of time during which competition could legitimately be eliminated, provided that long-term competition should resume. So just final slide, there actually are a lot of open questions. First one, I think, is a very difficult one in relation to the quantification of sustainability benefits. How can they be weighed against the loss of competition? You're often in the position of having to, carry out a trade-off of some fairly incommensurate losses and benefits, as the Commission itself recognises, in an area which is very difficult to do and where nobody has a lot of experience. Is cooperation necessary at all where consumers are willing to pay more in any event? And it may well be that consumers are. And would that provide a sufficient incentive on producers to invest and innovate in relation to some sustainability dimension of their offering without needing to cooperate with each other? And would cooperation in such circumstances simply result in lower standards than if individual actors were incentivized to compete in relation to their sustainability offering? And then how much weight to attach to out-of-market benefits, so benefits to the world at large or to some, consumers in some other part of the world, general societal benefits, what role do they play or what weight should they be attached to any of these sort of initiatives? If there is if the initiative results in higher prices for a small proportion of consumers, a small part of the population. And then there's a point as well in relation to compliance risk, where there is actually a difference between the Dutch guidance and the European Commission guidance in its effort to encourage these sorts of cooperation. The Dutch guidance says that fines shouldn't be imposed on competitors seeking in good faith to develop sustainability projects. There isn't any recognition of that in the Commission guidance. So, it will also be interesting to see how, in the coming years, how this guidance actually plays out, what sort of concrete projects might benefit from it or fall foul, and how, how forgiving might the competition authorities be of projects which might be regarded as good faith, but perhaps not strictly compliant. So I think I've used up my time, so I'll stop here, but happy to take any questions later on.
Thank you so much, Matthew. That was super interesting. And I know some of my students or the students that we have in climate law are going to be very happy about the mention that you gave on sustainability and shipping, because they have to write an essay about this in 2 weeks.
Right.
So Matthew, like what we'll do is also, like in the case of Leigh, questions, we will have them at the end. And then this is a very nice bridge that we'll take in from your presentation on sustainability and cooperation. That, as I discussed, this is going to be something very important for gas and hydrogen projects in the future. We already seen it in Norway in another department, which is the one on offshore wind. And then now we're going to be discussing what are the implications when it comes to Norway of the gas package and the hydrogen package. And this is going to be done by Henrik Bjørnebye, which is a partner in BAR, a law firm here in Norway. Henrik has also worked for many years in academia. So that used to be his previous job, but now he's joining us from legal practice. Henrik, you have 20 minutes like the other speakers. The floor is all yours. We look forward to listening about what are the implications of the package, sustainability, and Norway, which is a situation that we're not a member of the EU, but at the same time, we're integrated in the market of energy. We're so important for the EU. And we're looking forward to hear what you have to say. Is this something that we should care about here in the North? Thank you so much, Henrik, for joining us. The word and the floor is all yours.
Thank you very much, Ignacio. Thank you so much for inviting me and for hosting this webinar. I will try to share the presentation from my screen. Is it on your screen now? Sorry, and I'll just try to start the presentation as well. Is it? Sorry, I'm not able to start it due to this. Just hold on. There. You have it on the whole screen now, Ignacio?
No, because you probably have several screens, and then you're showing me the screen where you have the PPT open. Don't worry, it happens to me all the time, Henrik.
Oh, sorry.
I have 3 screens. I get all confused which one is which.
Let's see.
And you had a lot of digital teaching, Henrik, so you know how this is.
Let's see if we can get it to work. Now, is it better?
There, perfect. Thank you so much.
Thank you. Since we're a bit behind, I will try to limit my presentation to 10 to 15 minutes, just focus on the main parts to have some questions, some time for the Q&A as well. Now I'm not able to move it. Here we go. I should mention that this is sort of more of a preliminary view on the implications of this package for Norway for at least 2 reasons. First, it's an extensive, it's a large package. I think it's really just too soon to have any very firm opinion on what kind of implications this will have. And second, as Leigh mentioned, there are bound to be amendments, in particular due to the tragedy in Ukraine and what that might have of policy implications too. So these are just some very initial preliminary thoughts. And my main thoughts, or my 2 main points that I would like to raise, is that looking at this from at a very fundamental level, and considering this package as a part of the EU's climate goals and how they are being translated into law through Fit for 55 and subsequent legislative initiatives, then this whole work will, of course, have profound consequences for Norway in its energy transition, just as for any other EU EEA country. And in this respect, any initiative to develop further hydrogen markets, low carbon and the green hydrogen markets, will also obviously affect Norway, where both blue hydrogen and even more so green hydrogen projects are very much being discussed and focused on. So that's sort of the more fundamental view on it. And then it's possible to consider it from a more technical side and ask, will these specific provisions as proposed in this package, will they matter much in EEA implementation and national implementation in Norway? And I'm not so sure they will, viewed in isolation. And the main reason is that the provisions on upstream pipelines are kept as before in this legislation, and I will get back to what that means. Now, just to give a very brief history, and I will keep this very brief to save some time. The third energy market package from 2009 was, as we know, implemented in the EEA agreement in 2018, caused a lot of controversy due to the ACER regulation and how that was to be implemented in Norway. And it caused this controversy on the electricity side. On the gas side, however, there weren't really any discussion at all, and that has to do with the fact that the gas directive has separate provisions from upstream pipelines, which has a very much lighter touch on regulation than what applies to transmission and distribution. And the gas-led pipeline system on the Norwegian continental shelf has always been considered an upstream system. And in practice, we don't really have any downstream system in the sense of onshore transmission and distribution lines. At least it's very, very, very limited. So it didn't really matter much, the difference from the second to the third gas market legislation. Then we have had a lot of other legislative initiatives, the Renewables Directive implemented in the EEA agreement, Buildings Directive and Energy Efficiency Directive not so far, but bound to be so. We've had the whole network codes and guidelines process, both on the electricity and the gas side, but again, not of importance for Norway on the gas side, of great importance to Norway too on the electricity side, and the guidelines have been implemented in the EEA agreement and in Norwegian law. Network codes are likely to be so soon. We've had the clean energy package adopted at EU level, up for discussion under the EEA agreement at present, but with a time lag as the third energy market package. And then we now also have the hydrogen and decarbonized gas market package. So from a general perspective, basically everything that happens in terms of electricity and climate legislation is of great importance for Norway too. And then the gas market legislation hasn't been really that important. And if we look at the Fit for 55 proposals as well, I think at the very general level, a lot of those proposals, of the 17 proposals, including 12 legislative proposals, will be applicable and relevant for Norway too, if not all. And then how to deal with the gas and hydrogen package. And just to give a very brief background on the Norwegian upstream gas pipeline system, the sort of profound change in this system when it comes to infrastructure regulation and the transportation regulation happened around 20 years ago, when following the so-called GFU case, which was a competition law case that was at the end of the day settled, like most of the profile competition law cases in the energy sector. That led to a transition from the former, more planned joint field neutral gas sales from the Norwegian continental shelf to a system with company-based sales, Around the same time, the state reorganized its involvement in the sector. Statoil was part privatized, and a separate transportation operator, Gasco, as a state-owned company, was established. And Gasco is an ISO, an independent system operator. And then in 2003, a new gas transportation regime was adopted. Gasled was established as a new joint venture owning the gas infrastructure with Gasco as operator. And the gas directive was at least de facto implemented, where these upstream pipeline provisions were implemented. And they were implemented in the form of a regulated third-party access system, governed by overall provisions in the Petroleum Act, a separate Chapter 9 in the Petroleum Regulation, and then a subordinate tariff regulation setting forth an entry-exit tariff system for this gas infrastructure. At the same time, a downstream or a natural gas act was adopted for downstream onshore gas transportation. But as I mentioned, we don't really have a transmission or distribution gas system. So it has really very limited practical importance. So if we then look at these upstream provisions in the proposed new package, it really stays the same as in the third energy market package. I've just highlighted in yellow here the changes, which is just the really including natural gas. It doesn't have any, doesn't mean any substantive changes. And what this now Article 28 in the proposal states is that for these upstream pipeline networks, the member states need to introduce an overall TPA, third-party access system, with dispute settlement arrangements. And the member states can choose between a negotiated or regulated access system. And that's basically it. And Norway has opted for a regulated system, but a regulated system that is far less complex than what would follow from the third energy market package and the associated network codes and guidelines in the gas sector. And this really makes a lot of sense, given that this is, after all, an upstream system that has at its aim to transport gas from the fields on the continental shelf to the UK and continental Europe. There is a lot of issues in the more specific gas market legislation that has very little relevance for such an upstream system. For example, such as all the provisions concerning consumer involvement, and a lot of other more sophisticated provisions that you don't really need for an upstream system. And I just mentioned at the end here also that there is a separate issue on the extension of the security of gas supply regulation. And just to make it very brief, the security of supply legislation is, at least as a point of departure, beyond the scope of the EE agreement, as it's not really sort of internal market-oriented legislation. That doesn't mean that from a policy level, Norway will not contribute to the EU security of supply, but from a strict legal perspective, it's not necessarily part of the EE agreement. So I expect that this extension of the security of gas supply regulation will not really be applicable under the EE agreement, and the regulation itself has not been included in the EE agreement. So to sum up, and I realized I've done this very briefly, it's also to have some time for the Q&A. If we look at this from a fundamental point of view, I think that this package, as all other legislation promoting the climate objectives, and also promoting, in that sense, low carbon and green hydrogen solutions will certainly have an impact, although more indirectly in Norway as well. When it comes to the direct impact of this package, my preliminary thought is that I don't think it is likely to have much of a direct impact, in the sense that it will require Norway to implement new provisions for its upstream pipeline system. But having said that, it might, of course, still be a kind of legislation that Norway also will adapt to in a more voluntary sense in the long run. I think I will stop there. Thank you for your attention.
Thank you so much, Henrik. You were concise, succinct, very clear, and super interesting. And what you're telling us, it's going to make me sleep well at night. We might not have that much drama to implement this when the time comes, hopefully. And at the same time, what we're seeing is this in practice is probably going to have a lot of importance for Norway, because we are setting up ourselves as a land where hydrogen is likely going to be produced and exported. So what I'll do is I'll stop the recording of the session now.